that the police were looking for him, and after the police had camped outside his house the previous few hours. The applicant's home is in Kapseret, where the applicant also happens to be the area member of parliament. Upon his surrender at Langas police station in Uasin Gishu County, the applicant was brought to Nakuru Central Police Station. The following day, he was presented before the Chief Magistrate, Learned J.B. Carlo, in a miscellaneous application. The Republic, through the NCIC, sought leave of the court to detain the applicant for 14 days to give it an opportunity to conclude investigations and bring charges against him. In its application in the lower court, the Republic stated that it is doing investigations with a view to bringing 5 charges against the applicant as follows: hate speech, assault of a police officer, offensive conduct, unlawful possession of firearms and ammunition, contrary to Section 103 of the National Police Service Act. The learned magistrate had both parties and reserved a ruling for the 16th of September 2020. In his considered ruling, the learned magistrate held that the Republic had made out a case for the continued detention of the applicant for a further period of 7 days. The applicant believes that the decision by the learned magistrate is patently erroneous and amenable to revision or review by this court pursuant to the provisions of Article 165 of the Constitution, Sections 123, 362, and 364 of the Criminal Procedure Code. He has therefore filed the instant application dated 17th of September 2020, basically seeking orders of reversal of the lower court ruling. The matter was placed before me under certificate of urgency yesterday, that is the 17th of September. Owing to the nature of the subject matter and its urgency, I directed the applicant's lawyers to serve the DPP and return today for inter partes hearing. In doing so, I considered it critical to hear from the state before making any substantive or consequential decision on the matter. As directed, the parties appeared before me today for oral conversing of the application. I've carefully considered the oral representations of the parties' advocates, the constitutional and statutory authorities cited, as well as the decisional law quoted. I have also considered the scheduled submissions filed by the applicant's lawyers. I'm grateful to all the counsel who addressed the court, Mr. Nelson Harvey, Mr. Nathan Torore, and Mr. Hilary Sige, on behalf of the applicant, and Mr. Daniel Karuri for the DPP. Each one of them was resplendent in their blend of erudition and brevity. I should begin by dealing with a potentially dispositive procedural matter raised by Mr. Karuri for the DPP. That is, that it was a mistake for the applicant to have approached the court by way of revision as opposed to preferring an appeal. He argued that the applicant is not really advancing arguments about the regularity or illegality of the proceedings, but is dissatisfied with the decision of the learned magistrate. They, therefore, ought to have appealed against it. Mr. Harvey's response was that a revision was the appropriate step since no charge had been preferred against the applicant yet, and in any event, the Supreme Court has recently reiterated in the Joseph Lendrix Waswa case that interlocutory appeals in criminal matters ought to be referred until the final determination of the criminal trial. This is a path not open to the applicant given the nature of the application, Mr. Harvey argued. In R versus Mark Lloyd Stevenson, I dealt with a variant of this question and held as follows. In my view, the CPC provisions do not, however, mean that a party which has a right of appeal cannot thereby invoke the court's power to review a magistrate's court's order or decision. For clarification, it is important to state the right position that the High Court will usually exercise the power to review, to even exercise an appeal of an interlocutory matter before a magistrate's court only in exceptional circumstances. While difficult to determine with the mathematical precision when the court will use this power, it is only to be sparingly used where, in the words of South African authors Gardner and Lansdowne, grave injustice might otherwise result, or where justice might not by other means be attained. As the authors correctly write, the court will generally hesitate to intervene, especially having regard to the effect of such a procedure upon the continuity of proceedings in the court below. Hence, the propriety of exercising revision power for interlocutory matters is decided on the facts of each case and with due regard to the salutary general rule that appeals are not entertained piecemeal. In the present case, the applicant's counsel, as the applicant's counsel noted, there is no criminal trial yet. What is before the subordinate court are miscellaneous proceedings where a ruling has been made to the applicant in pre-charge detention. Both the terms of the Criminal Procedure Code, as well as the radically liberalized judiciary powers the High Court donated in Article 265 of the Constitution, clearly permit the applicant to approach this court for revision as he did. I will now turn to the substantive issue at hand. The singular question presented by this application is whether, in balancing the rights of the applicant, the interests of justice and public order, peace and security, in the circumstances of this case, there are compelling reasons to warrant the continued pre-charge detention of the applicant, as the subordinate court held. In reaching the conclusion that such pre-charge detention is warranted, the learned magistrate reasoned as follows. It was submitted on the quoting from the learned magistrate. It was submitted on behalf of the applicant, that is the state, that the respondent made certain utterances that the applicant says amount to hate speech which triggered demonstrations against the respondent, and its release from custody at this particular moment will disturb public order and security. The court is invited to balance between public interest and the right of the respondent to be released on bond. In the peculiar circumstances of this case, the court finds the public interest overrides the respondent's right to be released on bond at this stage. End of quote. A second reason the lower court gives for the continued pre-charge detention of the applicant is that the applicant is likely to interfere with potential witnesses. The learned magistrate reasons thus, like what? The respondent applicant, that is the applicant here, is a member of parliament for Kapseret constituency. It is clear from the commotion that occurred at the respondent's home on the night of Friday, 12 September, when the police attempted to arrest him, that the respondent is a person of immense influence, and the likelihood of him interfering with witnesses is real. As was held in the case of Sebastian Miriti, if the accused can influence witnesses, be it subtly or even through threats, it is a fact to be considered. The respondent is likely to influence potential witnesses. End of quote. The applicant insists that the court fundamentally misapprehended both law and the facts in its analysis and findings. In particular, in both the documents he has filed before this court, as well as in the oral arguments of his advocates before me, the applicant makes the following 4 points. First, that the finding of the Honorable Court that it was in the public interest to detain the applicant was an erroneous interpretation of the public interest matrix and inconsistent with the settled principles, and thereby negates the fundamental rights, freedoms, and liberties as set forth in Article 29 of the Constitution. The applicant argues that the court's decision was not proportionate in balancing the rights and liberties of the applicant against alleged public interest. The applicant argues that our jurisprudence has now established that when individual liberties come into conflict with national security, it is the latter which must give way, not the other way around. Second, the applicant argues that the court breached the fair trial rights of the applicant by stating merely on the basis of the state affidavit that the applicant's utterances amount to hate speech. Third, the applicant argues that it was an error for the court to have held that the applicant can be held in detention, notwithstanding that there was no holding charge preferred against it. The applicant argues that the police have no authority in law to arrest and detain any person without sufficient grounds and without informing of the reasons of his arrest, as required under Article 49(1)(a) of the Constitution. Fourth, The applicant argues that it was an error for the court to conclude that the applicant would interfere with unknown and undisclosed witnesses merely by the fact that the applicant is a member of parliament for Kapseret constituency and therefore influential. The applicant argued, placing reliance on William Kipkorir Kipchirchir case as well as the Dwight Sagare case, that for the prosecution to succeed in persuading the court of this criteria of interference, it must place material before the court which demonstrates actual or perceived interference, and that just suspicions and fears harbored by the prosecution are not enough. The state, on the other hand, supported the learned magistrate's findings and conclusions, insisting that it had persuaded the court on the basis of the materials it placed before it that it was in the interest of public security and order that the state is allowed to complete investigations before Mr. Sudi is released. Mr. Karuri argued that the state complied with Article 49(1)(g) and (h) of the Constitution because the state informed the applicant the reasons of his complete detention, which was that his immense influence in Kapseret would undermine efforts to record statements from potential witnesses. Mr. Karuri argued that the state was still conducting investigations and that it was incumbent upon the court to protect the integrity of the criminal justice system by ordering the continued detention of the applicant until the investigations are complete, since there is credible fear that he will undermine those investigations. Mr. Karuri submitted that the interests of justice demand the protection of the investigation process against probable hindrance by would-be accused persons. On the question why the state has not preferred a holding charge, Mr. Karuri argued that such a position would be untenable because such a charge would not be accurate in its particulars, hence undermining the foundational principle of certainty of charges as provided in Article 124 of the Criminal Procedure Code. Mr. Karuri, however, submitted that should the court be persuaded to grant bail, then it should bind the applicant, as he has already pledged in his affidavit, supporting affidavit, to keep the peace and not to make comments which might incite the public. It is probably rhetorically symmetrical, linguistically aesthetic, as well as structurally sound, for reasons which will emerge shortly. To begin with the applicant's most strident argument. That argument is that the judicial imprimatur given to the action of the police and the NCIC to hold the applicant in continued detention in the absence of a formal charge or holding charge is per se unconstitutional. The argument is that holding an arrested person beyond the 24-hour period prescribed in Article 49(1)(f) of the Constitution without charging them with an offense not to law is categorically violative of the Constitution. My senior brother, Kimaru J, in Michael Rotich v. Republic case, was of the opinion that a correct reading of Articles 29 and 49 of the Constitution yields the result proposed by the applicant. I've quoted at length what Justice Kimaru says in the Rotich case. Article 49(1)(f) of the Constitution provides as follows. An arrested person has the right to be brought before a court as soon as reasonably possible, but no later than 1, 24 hours after being arrested, and then G, at the first court appearance, to be charged or informed of the reason for the detention continuing or to be released, and H, to be released on bond or bail on reasonable conditions pending a charge or trial unless there are compelling reasons not to be released. The court, in the Michael Rotich case I just cited, while decrying the ubiquitous use of pre-charge detention, ruled that the constitutional meaning of to be informed of the reason for the detention continuing, which is the constitutional words used, can only be met with the presentation of a holding charge at the very minimum. There are good reasons for this purposeful reading of the Constitution. Why should the police arrest a citizen if they do not even have a provisional view of the offense the citizen has committed? It would seem repugnant to the ethos of the constitutional justification of the exercise of power and authority in which our constitution is steeped in, to encourage such practice, even if not categorically and constitutionally textual. In many cases, such police action would be, in context and effect, unconstitutional. This would be the case where the police conduct, for example, reveals a pattern or desire to overreach or to deploy the criminal justice system in a manner which unnecessarily diminishes rather than aggrandizes personal liberty or autonomy of the arrested individual. So, even while accepting that the text of Article 49(1)(f) may, in certain circumstances and contexts, comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reasons for his continued detention through the state's application to have him so held, the state must, in my view, satisfy a double test. First, the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. Second, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interest present in a potential criminal trial. That is, the rights of the arrested individual, the public interest, order, and security, the needs to preserve the integrity of the administration of justice, and lastly, the interest of the victims of crime where appropriate. By virtue of Articles 21(1) and 259 of the Constitution, the court must act to aggrandize and not diminish the personal liberties of arrested individuals in line with the other three interests. Differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail while balancing all factors within a complex permutation presented by these quadruple interests and without reifying or essentializing any. This framing of the test combines the four arguments the applicant made into a single multi-pronged weighted test. I will now apply it to the facts of the case. Can it be said that the state here is acting in absolute good faith and that the continued detention of the applicant without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances? The state's preferred reasons for the continued detention, which were accepted by the learned magistrate, were two. First, that the applicant exercises great influence on members of the public by virtue of his being a member of parliament, and that, therefore, releasing him created a foreseeable risk that he will interfere with investigations. Second, that given the charge he faces and given that there have been demonstrations against the applicant, his release from custody will disturb public order, peace, and security. Do these two reasons meet the high threshold in the double test I have synthesized above? I think they do not. I say so for at least three reasons. First, the argument that the applicant is likely to interfere with witnesses because he's a man of immense persuasion and influence seems eminently pretextual for at least two reasons. One, looking at the offenses that the state says it hopes to charge the applicant with, it appears to be a stretch on credibility to posit that any witness would be unduly influenced by the applicant. One, the critical elements of hate speech are provable not through individual witnesses who might come under the influence of the applicant, but by showing the ordinary import of the words uttered by the applicant were calculated to incite members of the public. Two, assault on a police officer would be proved not by a member of the public who may be susceptible to wither under the influence of his MP during investigations, but by the police officer who was allegedly assaulted. Three, unlawful possession of firearms and ammunition is proved, as the learned magistrate's ruling correctly held, through forensic, documentary, and expert evidence. Four, resisting arrest is also provable through the factual evidence of police officers who were present at the time of the attempted arrest. And 5, it is unclear what the offense of committing offensive conduct would entail in the circumstances here, but such generality and nebulousness of the allegations cannot be a ground for limiting constitutional rights of an accused person. 2, the state made no efforts whatsoever to demonstrate which witnesses would be interfered with and how such interference would happen at the investigation stage given the offenses contemplated. It is not enough to proclaim that an arrested person wields influence in his line of business, profession, trade, or occupation. In order to restrict the person's right to be released on pre-charge bail, the state must credibly and specifically demonstrate the likelihood of such interference. Second, the argument that the interests of public order, peace, and security necessitate the pre-charge detention of the applicant because his speech has led to quote-unquote demonstrations against him does not meet, in my view, the high threshold of compelling test required by our Constitution. The reason given appears illogical when set against the granted remedy to hold the applicant without charging him for 7 days, then releasing him. There is no indication how holding the applicant for precisely 7 more days will dissipate the public order, peace, and security risk his alleged utterance caused. I have noted that there is no allegation that the applicant has threatened to make like utterances if they are indeed capable of inciting the public. In any event, the applicant has demonstrated a willingness to abide by the condition not to make any comment akin to the ones the state finds insalubrious and capable of inciting the public. What then is the logic of his continued detention? In short, the radical remedy prayed for and granted to the state, which is to hold the applicant without charge for 7 more days, is not rationally related to the alleged risk. There is a second reason to worry about the contextual and simplistic pitting of public order, peace, and security on the one hand, against the personal liberty, interest, and autonomy of the applicant on the other. It is that the logic espoused by this simplistic pitting is a dangerous anti-liberty ethos, which was rejected by the Constitution of Kenya 2010. I clearly expressed this reasoning in Joseph Thiongo and 17 Others versus Republic, and it is sufficient to reproduce the relevant paragraphs. And I quote from that case: the defense would be correct to argue, this was a similar case that was in Kiambu, and this is what I said in that case. The defense would be correct to argue that such a blunt response to the breakdown in law and order would be tantamount to sacrificing the rights of the accused person in order to secure peace and security for the rest of society. Needless to say, our Constitution no longer countenances such an approach. Such was the approach to law and order that justified the authoring into our law books the infamous Public Order and Security Act. The logic that it is necessary to simply detain some quote-unquote dangerous citizens in order to maintain law and order for the rest of the society. That logic has been substituted in our Constitution with the opposite logic, that every accused person is presumed innocent and is entitled to bail and not to remain in remand unless compelling reasons are shown. The authority of the court to deny bail where compelling reasons are shown can now not be invoked as a reason for the security apparatuses and the state to refuse to undertake their foremost duty to protect all citizens and maintain law and order in the society. Where the alleged sources of threat are known and the potential victims of the illicit activities are known, it would be to reduce the state's monopoly of violence and duty to protect its citizens to a sacrilegious impotence to conclude that only the remanding of particular accused persons or suspects who are not themselves alleged sources of threats is the method to protect the potential victims and public order. Having reached here in my analysis, the result appears eminently tautological. The application herein largely succeeds. There are no compelling reasons for the continued pre-charge detention of the applicant. All the concerns raised by the state can be accommodated without the very radical measures sought and granted to the state to hold the applicant pre-charge for 11 days in the circumstances of this case. I must return to the words I stated in the Joseph Thiomo case that I cited before. And they are, I'm obliged to observe that the pathway to peace and justice chosen by our Constitution is one that assumes that aggrandizing personal autonomy and liberties, especially in the context of a criminal trial, is one that ensures our optimum aggregate collective peace, security, and justice more than the alternative path that limits individual liberties in order to safeguard these important values and outcomes. Ours is a constitution that wisely assumes that peace, security, and justice can be achieved in the context of the rule of law. For this to happen, each of the actors in the governance, law, order, and security sector must play the rightful role in ensuring sustainable peace, prosperity, and security. The disposition of the application then is as follows. A, the applicant, Sudi Oscar Kipchumba, shall be admitted to bail in the sum of Kenya shillings 500,000 with respect to all the charges the state contemplates to bring against him as covered by the state's application before the lower court. Alternatively, the applicant shall be released on his own personal recognizance of Kenya shillings 1 million and one surety of similar sum. These bail bond terms shall remain in effect and shall only expire upon the formal charging of the applicant with a disclosed offense or offenses. Upon such eventuality, the trial court shall be at liberty to set its own bail bond terms. B, the applicant shall not, and I hope Mr. Sudi is listening here carefully.
I'm so careful.
Mr. Sudi, are you listening here carefully?
I'm listening very carefully.
This is to you, not to your attorneys, okay? So, the applicant shall not, before a charging decision is made in this case, and thereafter, until the order is varied by the trial court, make any public utterances or comments akin to those he is alleged to have made, which the state alleges are capable of inflaming public passions and hostilities among communities. C, the applicant shall desist from addressing any public rally before investigations into this case are complete and a charging decision made. Okay, so the third one, I've only limited it to until a charging decision is made. After that, you can address public rallies, okay? D, the applicant shall report to any police station as summoned by the investigating officer for purposes of completing investigations. E, the state shall be at liberty to charge the applicant with any disclosed offenses once investigations are complete and charging decisions made. Meanwhile, F, the applicant, this is for you, Mr. Karuri, the applicant shall not be arrested or detained by the police. If a decision to charge him is made, he shall be summoned to present himself to court to take plea. Lastly, each party will be at liberty to apply for any further orders. I think you are still muted, Mr. President.
My Lord, on behalf of the applicant, we thank you most sincerely
Yes.
for giving us an opportunity to develop the law and to assert the authority of the sovereign of the people of Kenya. We are forever grateful. Be blessed and have a good weekend. We'll take Mr. Sudi all the way to Kapseret in confinement so that he doesn't speak about these things. You're most obliged. Thank you so much, Daniel Karuri.
It appears you might need, you probably might need the duct tape to keep him out of trouble. What the Karuri needs.
I thought we have asked Kemsa to design a leather mask.
Mr. Karuri, you have anything to say?
Much obliged, my lord, for your wise ruling. We are very grateful. We are developing the law. And just to remind the applicant that he's required on the 23rd of this month before the magistrate's court.
Before the CM.
Yes, my lord. We are
Sawa.
much obliged, and to the president and my fellow colleagues, thank you so much.
Asanteni sana, the ruling will be available with my court assistant in the next 5 minutes, so it will be sent to be emailed to you.
Thank you.
Okay.
Token, kindly.
Yes. Umima stano. Wamezama mnyamaza. iko sawa. Nini chukua mwezi. Aku ni nan. Cek kulit ekonu tu apa? Maka berusia. Ada nitoe mtu yetu. Komen. Kwa sana. Hii mheshimiwa bwana. Mheshimiwa ingia. Huyu mheshimiwa huyu. Mheshimiwa. Hata huyu mheshimiwa. Hata huyu unamwona. Hata huyu ayendo. Hata huyu ni mheshimiwa. Hata huyu.
Good afternoon, Kenyans. This afternoon, Justice Professor Joel Ngugi has delivered a landmark decision. Forgive me, I'm stagnating because the ruling is so eloquently and articulately drawn that we are all excited. What has the judge said? The judge has underscored several fundamental issues. The judge has said wherever there is a contest between national security and public interest vis-a-vis liberties guaranteed under the Bill of Rights, the Bill of Rights should always take prominence. And for that reason, the judge has said, much as the state may have its own anxieties resulting from the conduct, the utterances of Honorable David Sudi, his liberty is paramount. Oscar Sudi, sorry. And for that reason, the judge has said there is no justification whatsoever to continue detaining Oscar Sudi. That's number one. Number two, the judge has said there can be no justification whatsoever for the police to continue holding any suspect without a formal charge. We are all aware that up to date, no charge has been preferred against Honorable Oscar Sudi. And the court referred to a decision that was made much earlier by Justice Luka Kimaru on a similar issue. And therefore, an issue that is troublesome is an issue that we cannot understand as lawyers. Why the Office of the Director of Criminal Investigation continues saddling itself with this unnecessary embarrassment. The law is this. The only reason as to why somebody should be arrested will be because he's going to court to be charged. And the judge underscored as the second principle that the police should not use the power of arrest to conduct investigations. Conduct your investigations, complete them, then summon the suspect to come over, notify him that you're supposed to appear before court and take him to court. But fundamentally, and what I pick from that decision is the leadership culture in this country. You cannot settle personal scores. You cannot settle personal discomforts using the law. Because the law is always pure. And when you attempt to settle personal discomforts and scores using the law, the impurities will not pass through the sea. Today, impurities have failed to deter the rule of law from flourishing. And I want to encourage judges and magistrates to be as bold as the judge has been today. Because the biggest violators, the people who contravene the law most, are lawmakers, law enforcers, lawyers, judges, and magistrates. Why do I say so? I say so because they use the law to assist the state often in violating fundamental human rights and freedoms. This is a great day, not only for Oscar Sudi, but for all Kenyans. Because the constitution that you worked so hard to promulgate is the one that guarantees these rights. These rights are not given to you by the President of the Republic of Kenya. They're not given to you by myself. They're not given to you by a judge. You are entitled to these rights as soon as you are born Kenyan. And the rights must always be protected. That is what I gather from the decision of the court. The judge has released Honorable Oscar Sudi on a cash bail of 500,000 or a bond of 1 million. He has been asked to keep peace, and that request was founded upon the taking of Sudi himself, that he shall not make any utterances with respect to the matter that is currently under investigation until such a time as he will be arraigned in court, if at all he will be arraigned. Yes, that's all.
The judge in court who has asked the president of the Law Society plus lawyers like ourselves to reform, and as a former policeman from the rank of police constable to police inspector to intelligence, I'm sending this as a warning to the police in general, not to go back to the draconian way where they used to be whimed by the state to arrest people innocently and then drive them everywhere. And that's how I would like Parliament and the Judicial Committee in the Senate plus to pass legislation on venue so that nobody is arrested again and flown to another destination, therefore curtailing liberties of this particular person. Just like what has happened to our clients, because I'm representing him in the other case which is coming next week, that you can see somebody suffering and curtailing the umbilical cord of that person and society, including his family, that you can actually entrench fear in the community. This ought to end, and I'm joining my friend, Honorable Harvey, that's how I should call him, that the future of this country belongs to us and you, members of the 40th state, to disseminate information so that every Kenyan, wherever you are, go and read the first, not the first article of the Constitution, go and read the preamble and find out what we say. We the people, and that's what should be the guiding principle.